Good morning, everyone. Sorry about the feedback. We're just going to be waiting a few minutes for people to log on and then we'll begin the webinar. And my colleague, Katrina, who's assisting me this morning, will be putting her computer on mute. Good morning, everyone, and welcome to the next in the series of Boys Turner BCL webinars. Today, we are going to be considering two topics: business protection following COVID and recent developments in the area of whistleblowing. Whilst we wait for everyone to log on, and for those who have not attended a BCL webinar before, I want to say a few words about Boys Turner. We are based in the Thames Valley, and as you can see, I've moved the slides over, sorry, there we go. As you can see, we are recognised by both Chambers and Legal 500 as a regional heavyweight. We offer a full range of commercial legal services to a range of multinational and leading UK and European businesses. Given our location, we have particular expertise in the technology and innovation sphere, but also work across a number of other sectors, including leisure and hospitality, retail and development, and house building. In addition, in the past 12 months, we have developed a highly regarded and expanding immigration team, which deals with the major fallout from Brexit, the increased difficulty of bringing foreign nationals to the UK to work. There is on the webinar, you'll see a chat function. And if you have any questions, it would be very helpful to put those into the chat box. And I will try and address some of those questions at the end of the webinar. Where I'm not able to do that, then I will try and produce an FAQ sheet in a couple of days' time and circulate that to everyone. So my name is Barry Stanton, and I will be taking you through our topics today. I'm a partner in the employment and immigration team, and I'm also responsible for leading and coordinating the work of our business services group. So if anyone has any questions about any of those, then do let me know. Moving on to our first topic, business protection. I'm going to focus on some of the practical issues caused by the last 2 years. For the majority of us, prior to COVID-19, work followed a fairly traditional model, which generally required presence in a work environment for the majority of the working week. COVID broke that normality, as overnight we were all required to work from home for an extended period. The immediate consequence was that, other than being present online, employees were much less visible, and it was much easier for them to hide their activities from their employers. All of the normal indicators that an employee might be unhappy or considering a move were hidden away from us. So things like unexpected absences, ad hoc sick days, short notice requests for time off, and diving into rooms to take a call, those were all lost to us. There's also much talk now about the Great Resignation and whether that is a real phenomenon or illusory, and what are the reasons lying behind it isn't really for this talk today, but it's clear as a result of the stifled world that we've lived in over the past 2 years, employees are now more likely to want to leave and seek new opportunities. In addition, there is a war for talent as businesses seek to grow and expand, with the result that there is an oversupply of jobs for the available workforce. From all that we can read and experience in practice, it seems that employees want to embrace the new world of hybrid and flexible working, and that the ability to work flexibly is a key factor in then deciding whether to stay or look for new opportunities elsewhere. This is particularly important when there are more jobs than candidates, and attracting new talent can be difficult and expensive. Protecting businesses from employee competition starts here, creating an environment where employees want to remain and grow with your business. Inevitably, that is going to not work for everyone. We are seeing an increase in employee competition disputes involving breach of restrictive covenants and fiduciary duties, misuse of confidential information, and team moves. What should an employer be thinking about preventatively? Aside from ensuring that employees understand their role and place within the business and their opportunities to grow and develop their skills and career with their current employer, something which needs now more than ever to be actively managed. Part of the process must involve reviewing employees' contracts. The starting point is to ensure that all of the normal contractual requirements have been satisfied, because that's the starting point for an ex-employee considering an attack on their restrictive covenants. The importance of this was seen in a case called Patch Systems and Neely a few years ago, when it was accepted by the employer that the covenants imposed on Mr. Neely initially were unenforceable, because at the time they were imposed, they were unreasonable. However, he was promoted over the years with the result that if the covenants had been introduced at a later stage of his employment, they would have been enforceable. The downfall for Patch Systems was that rather than giving Mr. Neely a new contract when he was promoted, they amended the existing contract to pay him more money and give him additional benefits. But what they had not done was require him to confirm that the covenants were being entered into afresh on each occasion. Now, if an employee is being promoted or moved into a new role, it's good practice to ensure that the HR team issue him or her with a new contract for the new role before they start performing that role. At least in that way, it's very clear that there has been consideration for the new role and the restricted covenants that are in the employee's contract. In Zero Light and Wolf, an employer succeeded at the interim injunction stage in arguing that various new terms which were favourable to the employee, such as removing default retirement at 60 and the introduction of flexible working hours, were valuable consideration for the new restrictive covenants. So not a great deal has to be there. And I dealt recently with a case where the employees had been taken on but not issued with a contract for several weeks just because the employer was too busy. When the employees left and joined a competitor, it was very easy for the competitor to say, well, there was no contract in place at the start or no written contract, and therefore there had to be valuable consideration for the new contract that was issued a couple of weeks later. And that defeated any argument about the validity of the contract. Now, if covenants are being introduced during the course of an employment relationship, it's always helpful to set out in the document the consideration that is to be given for the acceptance of the new covenant. And that's really because in 4 or 5 years' time, no one's going to remember what the consideration for that new covenant was. Now, aside from contractual validity, there are some other contractual steps an employer can take to help bolster its position. Increasingly, covenants are being introduced which require the employee to draw the terms of any restrictions to the attention of any prospective employer. The purpose of such a clause is clear. It's an attempt to make the prospective hire less attractive to the new employer because they will know immediately that the employee can't do certain things. Whether an employee has done what they're supposed to do and disclosed the terms is always going to be difficult to prove. However, it might cause the new employer to stop and think if it becomes aware later that the employee has, after the employee has been recruited, that he did not disclose the information to ahead of time in compliance with his contractual obligations. And that might have allowed them then to determine how they were going to engage in the conflict that was to come in a different way. Equally, if the employee complies with their obligation, then it can assist an employer who wishes to claim that the new employer knowingly induced the employee to breach their covenants. And that might enable them to be pursued by the ex-employer for the economic tort of inducing a breach of contract. Another clause, which is becoming more widely used, is the obligation for an employee to disclose any offers from a competitor which the employee has received. And again, proving breach might be difficult, as may be establishing any substantial loss. However, there may be scope to bring a loss of a chance claim, loss of the chance that the employee could have been persuaded to stay, or loss of a chance that others who were involved in a team move could have been persuaded to stay if disclosure had been made at the appropriate time. Such a clause may deter some who are considering to leave as part of a team, or potentially impact upon whether a person is a good or bad leaver, because by failing to make the disclosure, they have acted in breach of their contractual obligations. And this might be important for those who hold shares or long-term incentives. Another reason was highlighted by Dyson and Pellery, where Mr. Pellery was subject to such a term if he received an offer from a competitor. Now, he was offered employment by Tesla, but did not disclose that fact because at the time the offer was made, so far as Mr. Pellery was concerned, Dyson only dealt in household electrical goods, and Tesla were not, therefore, a competitor because Tesla made electric cars. However, between the time of the offer and his resignation, he was transferred to work on a prototype electric car for Dyson. At that point, the obligations under the clause were triggered. In the course of about a month working on the Dyson electric car, Mr. Pellery obtained highly confidential information, which, were he to join Tesla, be inadvertently disclosed to him. On that basis, the court was prepared to grant a springboard injunction to Dyson. Whilst fiduciary duties will require directors and some others to disclose the wrongdoing of others, which may be helpful in a team move situation, more junior employees will not have such a duty. Equally, there is no obligation to report one's own wrongdoing unless it is imposed contractually. So imposing such a duty to report your own or the other's wrongdoing might be of assistance, particularly in a team move where not all the team are planning to move or are not being asked to move. Now, whilst none of these clauses will prevent an employee leaving, they can assist an employer either to paint a departing employee in a poor light or demonstrate a breach of contractual obligation. I want to consider now some of the issues for the ex-employer. An issue where competitive activity is discovered is who should be joined into any proceedings. Is it better to deal only with the departing employee, or should a new employer be joined? If only the employee is to be joined, then they will have fewer financial resources, and a new employer might be more willing or might be less willing to be involved. Equally, the risk of substantial damages being reported is also lower. Joining in the new employer leads to different considerations as to the proceedings against an employee, because they will have greater resources. They may at that point be more willing to fund the ex-employee in their fight against the former employer. And there is a greater financial risk, given the cross-undertaking in damages, that a claim against the new employer may be unsuccessful. And if damages are paid, they're likely to be far higher than any damages suffered by an ex-employee, which will usually only be loss of salary or commission. There's also the risk of subsequent litigation if, because as we know, competitors poach employees from one another. One of the new employer's employees is poached by the ex-employer. Now, generally, the ex-employer will write to the employee and possibly the competitor, outlining the employee's known breaches and asking for undertakings not to continue. By writing to the new employer at this stage, it also provides an opportunity to put the new employer on notice of what the employee is doing and the terms of their contractual obligations to the ex-employer. Now, that's important because it can help, it will help in any economic tort claim against the new employer. It's very usual to seek undertakings before issuing proceedings in an endeavour to avoid litigation. In the event that matters cannot be resolved at this stage, an ex-employer will need to consider whether it wishes to apply to court for an injunction. Having written to the ex-employee, it will already have some idea of the arguments that it might face and be able to prepare for that line of attack. If an application is made to court, it will generally be on an on-notice application, because that avoids the obligation of full and frank disclosure on an interim application, which then avoids later arguments about whether an injunction should be discharged for failure by the ex-employer to give full and frank disclosure to the court at the interim application stage. Gathering evidence. Very often, clients will seek advice when they have discovered that there has been an alleged breach of an employee's obligations and they want the employee stopped by injunction. Sometimes this is quite late on in the validity of the covenant. It always seems to me that the best form of defense is to ensure that those customers who were perceived to be close to the departing employee, or who may be targeted by the departing employee, are the focus of attention from the business, with key employees making contact with them prior to the employee leaving and in the immediate period thereafter. Being in touch with clients and in the marketplace is likely to be the best means of retaining the client, but also is likely to be the best means of receiving early warning that an employee is acting in breach of their obligations. My experience is that customers are quite likely to tell someone that they've met their former colleague Now, ensuring that there are policies in place allowing you the right to audit any private devices that an employee has, to check phone logs or emails in the period after an employee has resigned, may also provide evidence of unwanted behaviour. It's surprising how frequently automatic email addressing causes an email intended for an employee's personal account to be sent by a customer to their old corporate account, and that then can spark an investigation. Obviously, it will be important that any privacy notices have been suitably drafted to ensure that the employee does not have an expectation of privacy and that personal data can be accessed in this manner. Having in place suitable bring your own device policies, now that we're working remotely, will also be helpful. Even where there is no suggestion that an employee has acted in breach of their obligations, it might be sensible, rather than wiping their computer, for it to be imaged. And if something then crops up later, the image computer can be accessed and steps taken to find out what the employee was or might have been doing. Asking departing employees to confirm in writing that they've returned and or destroyed any information is a useful tool in an employer's armory, particularly if it later transpires that there are breaches of their obligation to return or destroy information. If it can be demonstrated that they've signed the confirmation but retained documents, even inadvertently, it helps paint a picture of an untrustworthy individual. Exit interviews can also prove a useful source of information, as they allow the employer to ask questions which might cause the employee to inadvertently disclose something they would rather not have done. Obviously, with hybrid working, it's more difficult to catch out employees or catch them off guard because meetings now tend to be arranged online well in advance, and they're also less likely to be caught out copying large volumes of data or making calls. Obviously, this is all a double-headed coin, and I want to just focus for a few moments on issues for the new employer. If it knows that the arriving employee has restrictions, it might want to consider whether there is anything that can be done to avoid breaching them. An obvious example would be in a group situation, in the case of a non-competition covenant, employing the employee in a non-competitive business, which would make it more difficult for the ex-employer to argue if there'd been any breach. Equally, an incoming employee may be potentially so valuable that it is worth recruiting them and allowing them to sit out their covenants rather than incurring the potential costs of injunctive proceedings. A key consideration will be ensuring that the employee has not brought any confidential information with them, which they then incorporate into the new employer's databases. If that were to happen, it would expose the employer to proceedings and an obligation to ring fence and hand back the confidential data, which can be an expensive exercise. I recall one conversation with a sales executive who I worked with over a number of years, who explained to me that in every company he worked with, when a new employee joined, all of the sales execs gathered around and they acquired the information they wanted to from the new employee. Now, obviously, that's a breach of their obligations, but it's very difficult to prove. New employers should consider whether to ask the employee to confirm they've complied and will comply with their obligations not to disclose confidential information, which may then help the employer be protected against proceedings. Now, if an employer has decided to take the risk of proceedings, the new employee may be very concerned to know who will be responsible for their legal costs, which may be substantial. If the new employer is going to agree to meet those costs, it should be very clear about the terms on which it will meet, whether it will impose a cap on those costs, or if the cost indemnity is limited in some other way, what the limitations are. In some instances, it might be appropriate for employer and employee to instruct the same firm, but if there are potential conflict issues, the employee should be separately represented, but that's an issue that can be considered further down the track. If the new employee is caught, it might be prudent to consider whether there will be any appetite to offer undertakings to the ex-employer about the employee's conduct during the period of restriction. Considering whether undertakings are palatable and what they might be can be helpful in focusing a business's mind on whether they are truly willing to enter into a fight over post-termination restrictions. An obvious example might be agreeing not to solicit or deal with customers with whom the employee dealt, but not agreeing to give undertakings in respect of general non-competition. So I wanted to focus a little bit on interim injunctions. Sales teams and managers will generally want to enforce all restrictions to ensure those who remain behind comply with their own obligations. Where this is the case, it will be important to ensure that the application is likely to be successful. Seeking an injunction and failing because the covenants are unenforceable will mean that the employer's covenants with other similar employees are also likely to be unenforceable. It may be, given the cost involved in making applications, it's only worthwhile pursuing those who are most likely to cause damage. Now, the threshold for obtaining an injunction was set out in American Cyanamid and Ethical in 1975, where it was held that there must be a good, arguable claim, or in other words, there must be a serious issue to be tried. The threshold is not particularly high, and as was noted by Lord Diplock, who said that it was sufficient that the claim was not frivolous. Damages must not be an adequate remedy, and this may arise where the defendant cannot pay any likely damages, or they will be difficult to quantify. In assessing whether damages would be an adequate remedy, the court can take into account the length of the covenant, the potential size of any losses, and the means of quantifying. The courts often note that demonstrating causation, that's to say, an account was lost because of the employee's breach, may be very difficult, and therefore they're more willing to grant the injunction. The court must also consider the balance of convenience. This involves a number of issues. Whether the applicant will be able to pay the cross-undertaking and damages. If they will not, or quantifying damages will be difficult, then that may count against or count in favour of granting an injunction. In the employment context, with any sizable, whether the applicant will be able to pay the cross-undertaking damages. So in the employment context, one would expect that an employer, any sizable employer, would be able to pay any cross-undertaking damages to an employee. It may be different if damages in respect of a third party who are engaged in the proceedings, such as a new employer, where they're likely to have substantial damages. That may be more problematic. Where is the balance of harm? Will more harm be done by granting the injunction or not granting it? And the overriding view of the court seems to be that, at least in the employment context, having decided that there is a serious issue to be tried, that the balance of convenience rests with granting the injunction. Equally, if the balance of convenience is unclear, the court will favour maintaining the status quo. A factor which may count in the ex-employer's or count against the ex-employer is delay. So if an ex-employer finds out about a breach, it can't delay too long. Now, whilst the general position is that the merits of the case are not relevant, there is an exception where a speedy trial is not possible before the restraint has largely run its course. The same is true where the period of the covenant is relatively short and a trial will not happen until the restriction has expired. One of the difficulties for those seeking injunctions is therefore how much detail to go into about the reasonableness of the covenant, given the risk that a trial may not take place for some time. It would be prudent to make as detailed approach and a statement as possible to set out why the covenants were needed and why they're reasonable. The starting point for restricted covenants is that covenants are an unreasonable restraint of trade, but that provided they are no wider than reasonably necessary to protect the employer's legitimate business interests, they will be enforced. The burden of establishing this is on the employer. Very often, there will be nothing to demonstrate why a covenant which is in place was introduced and why at the time it was introduced, it was considered to be reasonable. Whilst this is frequently not an issue and people can bring after the event justifications, it's always helpful when covenants are being introduced to have some form of note or rationale about why that particular covenant was required for that particular employee. And duty of fidelity. Well, establishing there's been a breach of duty of fidelity can be useful and helpful. Obviously, directors will owe such duties, as will those who are de facto directors. Now, an individual will be a de facto director if they are part of the corporate governance system of the company and if they have assumed the status and function of a director. And equally, although a person is not a director, they may be sufficiently senior to owe fiduciary duties. And in seeking to ascertain whether someone owes fiduciary duties, it's necessary to identify the employee's duties and ask whether in all the circumstances, the employee has placed themselves in a position where they must act in the sole interest of the employer. And key factors in determining the issues are the nature of the breach, the employee's seniority, and the company's vulnerability to abuse by that individual. And this is particularly relevant where the individual is effectively in sole charge. Where confidential information has been misused, there are a range of orders available. Preventing an employee from passing that information on to third parties is always an order that's going to be sought. Where there has been wrongdoing, applicants will generally need to know what has been done so that they can attempt to undo it. So it's very usual to seek affidavit evidence of what use the employee has made of that information. And again, if confidential information has been retained, an employer is going to want to have that information returned to it or deleted. But that poses a problem for those who have taken data electronically about how one can actually delete irretrievably an electronic file. The courts may also be willing to grant an order that electronic devices be imaged to preserve documents. And it seems that the ability to obtain an order to inspect ahead of ordinary disclosure would only arise if it was needed to enable the ex-employer to plead their claim. So getting an imaging order is something that one should always ask for, even when you're asking for undertakings. And then you can try and get an order for disclosure, but that's going to be more problematic at this stage. Springboard relief was originally available for misuse of confidential information and is now also available for breach of contract and breach of fiduciary duty. And it's a very flexible remedy, which is designed to meet the harm that has been suffered by the applicant. It was originally, as I say, available for breach of confidence and to prevent those who'd taken data and information using it as a springboard for detrimental activities. Now what is needed is the obtaining of a head start by unlawful means. The head start that has been gained must still be in existence at the time that the application for an injunction is made. For example, if designs had been taken and used, which would have taken the new employer 12 months to create without copying, the advantage is that period of 12 months. And the purpose of granting the springboard injunction is to ensure that the competitor does not secure a competitive advantage. And it's for the employer to set out the nature and period of that competitive advantage. Springboard orders are flexible and can go beyond what might be covered by restrictive covenants, so they're always worth considering. They can be used to prevent the ex-employee and the new employer contacting customers whose names have been passed to them unlawfully. And in the context of team moves, where more junior employees have been enticed unlawfully by more senior colleagues to move, to prevent them moving to the new employer. Now, I mentioned the case of Dyson and Pellery, where the court granted an injunction to prevent Mr. Pellery being employed by Tesla, and they based that upon a restrictive covenant. But the court also said that if there had been no covenant, it would have granted a springboard injunction. And they can also, in extreme cases, be used to prevent the launch of a competing business. And an example of that is the case of QBE and Dimmock, where the court found an intention to acquire the employer's business by stealth. So that's all I wanted to say on restrictive covenants and protecting one's business. I'll take any questions on that at the end. And I'm going to move now to look at some issues around whistleblowing. The number of whistleblowing claims are increasing. As we can see from the slide, employment tribunal statistics from 2021 suggest they've increased by 43%, and that's a 43% increase in the period from 2017-18. So in 2017-18, there were 2,191 whistleblowing claims and 3,128 claims in 2020-21. But in the same period, the total number of claims increased by only 7%. Of these, statistics showed that only 3% were successful, whilst 24% were unsuccessful. But what is unclear is how many settled, and of course, on what terms they settled. Now, the challenge for those being forced to defend whistleblowing claims is that they are generally complex, intertwined claims that are time-consuming and expensive to deal with. And whistleblowing claims are one of the few claims which allows a former employee to make an application for interim relief. And historically, there have been very few such claims, but they now seem to be on the increase. And if one looks at the slide, it's quickly obvious why applicants are making more applications for interim. Firstly, the time to get to a hearing has become longer due to the effects of COVID-19 and the pressures it brought to the employment tribunal system. And if successful, the applicant is entitled either to be re-engaged, re-employed, or paid up to the date of the hearing, which clearly for an ex-employee is a very valuable remedy. Applications for such relief must be made within 7 days of the date of dismissal and must be heard by the tribunal as soon as possible. In addition, there is no obligation on the claimant to go through the ACAS early conciliation process. So it's so the applicants have only a very short period to get their claims in. The employer must be provided with the application at least 7 days before the date of the hearing. And if an application is made, it will usually involve a lot of urgent activity to prepare pleadings and witness statements and any other relevant documentary evidence. And the test to be applied on an application for interim relief is whether the claimant has a pretty good chance of success at trial. And some of the implications of interim relief applications are seen in Robinson and Al-Qasimi. And it's worth noting at the outset that from the date of issue of the proceedings to the actual initial interim relief hearing was only a period of about 3 or 4 weeks. So it does get the applicant, the claimant, into an employment tribunal setting very, very quickly. The facts of Robinson were slightly odd and related to a claim being brought by a lady who said that she had been not paid her wages properly, and the defense being that the contract was illegal. But those issues don't really affect us, so I'm not going to focus on those. But Mrs. Robinson complained that she had been unfairly dismissed for making protected disclosures. She also brought a claim for ordinary unfair dismissal and, as I said, unlawful deductions from pay. She applied for interim relief and was successful. And Mr. Al-Qasimi appealed, and his appeal was also successful, and the case was remitted back to the employment judge to reconsider. The application was reheard, and before a decision was made, the substantive proceedings commenced. And that meant that the interim relief decision was handed down to the parties on the 2nd day of the trial, and the claimant was again successful. Subsequently, the trial held that the claimant's case should be dismissed on the basis of illegality, and the respondents applied to the employment judge for him to reconsider his decision on interim relief because the claimant had failed. But the application was refused. And the case was appealed to the Court of Appeal, where they found that even if the outcome of the unfair dismissal trial is known, it's not relevant to whether an interim relief order was properly made. So it's entirely possible for someone who is successful on an interim relief application, losing at trial, but still being paid all the way through to the trial and being able to retain those payments. So what is a qualifying disclosure? Well, it's any disclosure of information which in the reasonable belief of the worker making the disclosure is made in the public interest and tends to show one or more of the following: that a criminal offence has been committed, is being committed, or is likely to be committed; that a person has failed, is failing, or is likely to fail to comply with any legal obligation to which he is subject; that a miscarriage of justice has occurred, is occurring, or is likely to occur; that the health or safety of any individual has been, is being, or is likely to be endangered; that the environment has been, is being, or is likely to be damaged; or that information tending to show any matter falling within any one of the preceding paragraphs has been, is being, or is likely to be deliberately concealed. So I think we need to focus on disclosure of information, the reasonable belief of the worker, public interest, and then tending to show a criminal offence, a failure to comply with legal obligations, a miscarriage of justice, the health and safety of individuals being endangered, and damage to the environment. In Kilrain, it was said that for there to be a disclosure of information, there must be sufficient factual content and specificity. I'm going to need to put my teeth in for that, and I'll say that quite a few times, tending to show one of the matters in subsection 1, i.e. those matters there. And what is required from section 43B has been considered on many occasions, including in the case of Williams and Michelle Brown, which breaks the definition down as follows. There must be a disclosure of information with sufficient factual content and specificity to be capable of showing any of the matters set out in paragraphs A to F. That's the criminal offence, endangering health and safety, etc. The worker must believe the disclosure is made in the public interest. If the worker does hold such a belief, it must be reasonably held. the worker must believe that the disclosure shows one of the prescribed matters. And if the worker holds such a belief, it must be reasonably held. Now, in Twistx and Arms, Dr. Arms was the managing director of Twistdx, and he was a research scientist. The company had been ultimately acquired by Abbott Laboratories, and in 2018, both Dr. Arms and his wife were dismissed, and they brought unfair dismissal proceedings, including in Dr. Arms's case, a claim based on whistleblowing, which, as the Employment Appeal Tribunal judgment noted, was set out in considerable detail in a 56-page, single-spaced particulars of claim. He alleged that he'd been victimized and ultimately dismissed as a result of disclosures he made in connection with a DNA sequencing technique marketed by the company, which meant that the results it produced were unreliable. He alleged that he had made 7 disclosures, 6 by email and 1 orally. He alleged that the disclosures related to the commission of a criminal offence, failure to comply with a legal obligation, endangering the health and safety of an individual, and that these matters were being deliberately concealed. There was an application by Twist to strike out on the basis that the disclosures which he pleaded could not satisfy the statutory definition. The starting point was question 1, was to identify the information disclosed by the worker. And having taken account of the comments in Kilrain, Mr. Justice Linden in the Employment Appeal Tribunal concluded that it was permissible at a strikeout hearing and at trial to take into account witness evidence as to context and meaning. So that meant that it wasn't just necessary to look at the words used, but one could take into account a wider set of facts. And this presents problems for employers because it will then become a mixed issue of fact and law, which means that any attempt to strike out on the no reasonable prospect ground will be met with the problem that the Employment Tribunal will be being asked to decide a mixed issue of fact and law. And that's something it can't do until it gets to a full hearing and hears all the evidence. The next issue was to determine whether the claimant believed at the time of the disclosure that the information tended to show one of the required grounds, and that's a subjective question. Whether a claimant holds such beliefs at a strikeout has to be assumed in the claimant's favour. However, a tribunal must identify which type of disclosure has been made because that will affect the reasonableness question. But the belief is only a belief that it tends to show rather than does show, which is a lower threshold. On the question of whether the claimant believed that the information tended to show one of the required grounds, the Employment Appeal Tribunal noted that it was a lower hurdle than does show. And what is clear is that whilst a worker may believe something, the belief may be reasonable but wrong. For example, in another case, believing that something was a criminal offence when it was not was held to be reasonable, although it was incorrect. It wasn't a criminal offence. And even if the Employment Tribunal disagreed with the worker's views, that doesn't mean automatically that the belief is unreasonable. The next question considered by the Employment Appeal Tribunal was how directly the qualifying disclosure has to refer to one of the specified matters. And on behalf of the employers, it was argued that it would be unfair to an employer if they were to dismiss an employee for disclosing information, only to discover after the event they had dismissed him for making a protected disclosure. And what they said was that either it must be obvious from what was said, or the worker must expressly state that they are accusing the employer of criminality or one of the other specified matters. And the Employment Appeal Tribunal rejected the argument, noting that if a worker expressly states their concern, for example, the reported information shows criminality, then it will be harder to question what the worker's belief was. But they said if the Section 43B is not stated, and they don't say this is a criminal offence or you're concealing a breach of health and safety, and it's not obvious, then it's much more difficult for the employee to say that they held that belief. Now, public interest has been much litigated over the years. And in Ibrahim and HCA International, Mr. Ibrahim worked for HCA, which is a private hospital. And in March 2016, he met with a manager and asked her to investigate rumours that he'd been involved in breaches of patient confidentiality and alleged unprofessional conduct towards him. His complaint was not upheld, and he applied to the Employment Tribunal on the basis that he suffered detriments on the basis of the disclosures he had made. And the Employment Tribunal dismissed his claim on the basis that the disclosures were not qualifying disclosures and they were in any event not disclosures made in the public interest, but were rather made with a view to him clearing his name and re-establishing his reputation. His appeal to the Employment Appeal Tribunal was dismissed, and he appealed to the Court of Appeal. The Court of Appeal referred to the decision in Chesterton and Nur Mohammed, which is a two-stage test, and they then said the tribunal has to ask whether the worker believed at the time he was making it that the disclosure was in the public interest, and whether, if so, that belief was reasonable. And they said that the tribunal here had enlightened the two tests, and what should have happened was that he should have been asked whether at the time he made the disclosures, he believed he was acting in the public interest. And if he'd at that point answered yes, he could have been asked for an explanation, and he could also have been cross-examined on that as to whether it was just simply an afterthought. Now, in Dobby, Mr. Dobby worked as a consultant for his employers, and his employers were a firm of solicitors. And he subsequently qualified as a solicitor, but later his contract was terminated. And he alleged that this was because he made disclosures about what was happening in relation to a particular client, and he said that the client was being overcharged. Now, the Employment Tribunal accepted that he disclosed information which he believed tended to show the client had been overcharged, that this tended to show a breach of a legal obligation, and that it was reasonable for him to hold those beliefs. However, it held that he did not reasonably believe that the disclosures were in the public interest, and the rationale was that the disclosures were made to enhance the prospect of recovering costs following a successful claim on behalf of the client. The Employment Appeal Tribunal overturned the tribunal's decision, and they said the tribunal had not focused on the information being disclosed. There was a reasonable belief that a client was being overcharged and breaching a contractual and regulatory obligations, and it said that solicitors, as officers of the court, are held to very high standards. It went on to say that if a claimant held a reasonable belief that he was disclosing information to the respondent that tended to show it was overcharging the client in breach of regulatory requirements, and that this disclosure was made in the public interest, the disclosure did not cease to be protected because it was done in the context of him arguing that this issue was important because of the effect it might have on the taxation of that individual client's costs. So when considering public interest, the number of the group affected needs to be considered. However, there is no requirement that there must be a group of people who are affected. A disclosure can be in the public interest if it relates to just one person, even if only that person was protected. The disclosure could have been in the public interest because here the disclosure could have advanced the public interest in clients not being overcharged. And there was a very interesting discussion in Dobby about public interest. And the EAT noted that what interests the public may not necessarily be in the public interest. The public may not be interested in disclosures which are actually made in the public interest. But it also said that disclosures falling within section 43B1 are often going to be in the public interest. But the public interest test may be failed for many reasons. And simply because a disclosure is in someone's private interest does not prevent it being in the public interest. So when looking at this type of situation, it's always important to look at the wider context. I wanted to focus a little on causation. In Dobby, the tribunal found that disclosures made by him had little influence on the decision to dismiss. And the Employment Appeal Tribunal looked at that question and said that they'd applied the wrong test, and noted that the Court of Appeal in the earlier decision of Beckett had commented that liability arises if the protected disclosure is a material factor in the decision to dismiss. And causation has also been considered in two other cases, Kong and Martin and Devonshire's. In Kong International, the tribunal found that dismissal was not tainted by whistleblowing. Here, the claimant raised concerns about risks posed by a financial product, and the head of legal who drafted the document disagreed with the claimant's views, and a discussion took place, which was then followed by an exchange of emails. The head of legal believed that her integrity was being questioned and impugned, and raised the matter with the head of HR and indicated that she could no longer continue working with the claimant. The head of HR and the CEO concluded that the claimant should be dismissed, and the group auditor also agreed, and the claimant was dismissed. The claimant brought a claim under both Section 98 for ordinary unfair dismissal and under Section 103A, so under the whistleblowing legislation, but only her Section 98 claim succeeded. In the Employment Appeal Tribunal, whilst it was noted that the head of legal's motivation for wanting the claimant dismissed was the disclosure she had made, that was not the motivation of the managers who dismissed. And the AT said that in these circumstances, the head of legal's motivation should not be imputed to, because they carried out their own investigation and the head of legal had not been involved in any way in reaching a decision about whether the claimant should or should not be dismissed. In reaching the decision, the tribunal was alive to the issues in Martin that tribunals have to be aware and take note of the real motivation, what the real motivation was for dismissing. The Employment Appeal Tribunal in Martin recognized that the question in any claim of victimization is what the reason that the respondent did the act complained of is. If it was wholly or in substantial part that the claimant had done a protected act, then they're liable for their victimization. And if not, they're not. And they recognize that where an employer has dismissed an employee or subjected him to some other detriment in response to a protected act, it can, as a matter of common sense and common justice, say that the reason for the dismissal was not the complaint, but some feature of it which can be treated as separable, such as the manner in which the complaint was raised, or a breakdown in the relationship, which is quite separate from that particular complaint. So this does indicate that whilst tribunals are going to be astute as making that separation, it is entirely possible for tribunals to be persuaded there is a separation. So applying to strikeout, should employers consider a strikeout when faced with a whistleblowing claim? Well, employers should consider whether the factual allegations are sufficiently strong to withstand a strikeout application, either on the basis they are demonstrably false in the light of incontrovertible evidence, or that even taken at their highest, they cannot succeed in law. But it's going to be difficult, as we've seen, to disprove a subjective belief prior to a full trial. The most likely and successful line of attack will be that even taking into account context and relevant facts, as in Twistdx, that the disclosures lack sufficient factual content or specificity. In Twix, you'll remember, there were 7 alleged disclosures, and the AT dealt at some length with the issues to be considered and took into account whether there was information of such factual content and specificity to be capable of falling within section 43B. And it noted that in some cases, Dr. Arms had not referred to the fact that at the time he made the alleged disclosures, he held the requisite beliefs. But they said even if he did in some cases, they were not reasonable. So there were 7 alleged disclosures. And in respect of those 7, 6 were struck out by the Employment Appeal Tribunal and only 1 allowed to proceed. And it's worth just looking at one of those. Dr. Arms said, I set out my concerns that the lack of forward planning to deal with sudden and potentially catastrophic product events could be very disruptive to the development of products in the development cycle. And that was alleged to be a disclosure. But that disclosure was struck out as lacking the necessary factual content and specificity. The one that was allowed to proceed was one where he said, in reality, a much worse, more complex scenario might evolve. And he went on to say, this might not get noticed, but compromises the system in a clinically meaningful manner. And then he said, I am obligated, however, to set out my concerns, which pose both a business risk, but also, more importantly, a regulatory one. So you can see very clearly there that Dr. Arms had tied the disclosure to the relevant alleged breaches. But the interesting point was that the Employment Appeal Tribunal, having decided that 6 of the disclosures should be struck out, provided Dr. Arms with a period of 28 days to amend his claims in respect of those disclosures, which lacked the required factual content and specificity. Now, I don't know what Dr. Arms did, but inadvertently, by applying to strike out, the employer had created a situation where Dr. Arms was now being given an opportunity to improve his claim by pleading the necessary factual detail. And equally, if he didn't do that, what had happened is that he had weeded out those claims which were weaker and which would have tainted any claim which he might have wanted to produce or what he was any claim which he had pursued before the Employment Tribunal. So those are some of the factual issues and factual matters to take into account on Strikeout. I'm just going to ask Katerina if there are any questions, and I think there may well be some.
No one's written anything, so just maybe ask if you have any questions.
I'm told there are no current questions, but if there are any questions that people want to raise, please let me know. We'll keep the link open for a few minutes. And if there are any questions that arise subsequently or any issues that you want to discuss, please do let me know, and I'll be very happy to deal with those. And my contact details are on that slide. Okay, well, there's nothing coming through. I want to thank all of those who stayed to the end for listening. Thank you very much. For those who watch this on playback and repeat, I hope you enjoyed it. And if I can assist in any way, please don't hesitate to let me know. Thank you very much.
Ooh. Sorry, it's fine. Yeah.
I've got 2 questions.
Can you get a copy of the recording, which we send anyway? So,
What do I do now?
just leave.
I just, where do I go there? How do I do that?